On the air since 1951. This is the legend. 105.3, 95.3, WDXE.
It's time for Bulletproof Estate Planning with my friend Stan Pierchoski. It's been a couple of weeks since I've seen you.
Good morning, Jeff. It has been. I think last week you were on vacation. A week before that, I had double scheduled something that I had to.
Yeah.
I couldn't. I had to choose which one to go, and it was a doctor thing. I had to go there. So anyway, but yeah, it's been a few weeks. I don't know, but LB filled in both of them, I guess.
Yeah.
And I don't know. It's this last week seemed to have gone so fast. I mean,
yeah.
I do the radio at your ex-sister station over in Pulaski on Thursday mornings. And it was like, good gosh, I was just here.
Yeah.
This was a fast week, but it was a good week too. But anyway, you had a good vacation, I understand.
We did. Yeah, we had a nice little trip down to the beach, and
we were talking a little bit off mic about just how vacation should you be busy doing stuff, or should you just be chilling? A lot of people, some people like. I want to go this, but I want to go to shows. Like Gatlinburg, I want to every night go to a show and go do this and go do that. I'm a little less. I like to be a little less active on my vacation.
Yeah,
I like to spend time doing nothing.
Yeah,
and I think that's. I mean, it's certainly a personal preference, but I mean, that's the way I like. That's why I like cruises so much, because you can just kind of chill out big time.
Yeah, you and I were talking about that. I've never had the privilege of being on a cruise yet, but you said you've enjoyed that.
I have, and I'm going to tell you a story about a real short story. But as soon as we tell folks that this is our show called Bulletproof Estate Planning.
Yes, it's
an interactive show, and if you want to call in, the number is 931-766-9393, and you can share experiences or ask questions.
Yeah, absolutely.
It's a personal question. Just kind of generitize it if you can. If generitize is a word.
Yeah.
And I'll just give me the facts, and I can answer it that way. But real quickly, we were on a cruise one time, and they always have a lot of good shows. My wife and I like shows. Being associated with the theater, which, by the way, Anne from of Green Gables is on. Tickets are on sale.
Oh, really?
Coming right up. Yeah.
Okay.
And anyway. There was a show. It was a musical show, and it was a cover band. The band ABBA, right?
Yeah.
This group was called, I don't know, ABBA Cadabra or something. It was a cover name. It wasn't them, but they were like them. They did nothing but their songs, right?
Yes.
And they were very good at it. Okay.
Yeah.
And it was entertaining. In between songs, they do some things, and it was very entertaining. But
sure.
What I remember was at the very end of it. It was about maybe not almost 2-hour show, because ABBA did a lot of songs.
They did do a lot of songs.
So these guys sang all these songs. Okay. And they got to the end of it, and they were kind of telling the audience that they were wrapping up. Going to do one more song, and they did this last song, and they started thanking the audience and stuff. And the song they never played was "Dancing Queen," which is iconic for ABBA, right?
Right.
And so the whole audience started yelling, "Dancing Queen, Dancing Queen!" And the guy that did a lot of the talking, he says, "What?" He says, "What are they saying?" He turns to other band members and says, "What are they saying?" And he comes up to the front of the stage and goes, "What?" And of course, everybody's yelling and talking, "Dancing Queen!"
Yeah.
All together, right? "Dancing Queen!" He put his hands over his ear, and he was "Dancing Queen!" He turns around the band and he says this. He says, "This is crazy. They want to hear something by Queen." So what they did was they started playing Bohemian Rhapsody.
Yeah.
Which is like a 9-minute song, but it's not. It's not Queen. I mean, it's not ABBA.
Yeah.
And they started playing. I'm gonna say maybe a minute into it. When the key was just right, they just transferred right into Dancing Queen, and they finished the show with Dancing Queen, and the crowd was going, "Wow!"
Oh, cool!
I just thought that was so funny.
I'll
never forget that. They want to hear something by Queen. That worked in so well. They must have had to give that a lot of thought for that to work, because they knew at the end of the show we hadn't paid their iconic song that everybody wanted.
Everybody's going to want that song. That's right.
Anyway, there's lots to do. You can do a lot on cruises, because everywhere they stop, you can do what they call a land excursion and go. Yeah. I usually don't. I like it because a lot of people go do them, and then the boat's kind of empty, and I just hang out. I just like to hang out and walk around. They have the last one was one they had a pizzeria, little small shop. They made pizza, and I walked in there and said, because you don't pay for food because you pay up front, you just show up and eat. And I went to this pizzeria, and I said, and I like anchovies. My wife won't eat. First of all, I can't get a pizza with anchovies anymore. And my wife won't let me bring one into the house. Because she says it pollutes the whole house. So, but I do like it. And so I go down there and I said, "Do you have any anchovy pizza?" And he said, "No, but I'll make one." I said, "I just tell him a piece or two." He goes, "No, I'll make you anchovy pizza." So he makes a great big old 16-inch pizza for me. He hands me 2 pieces. I ate them, and they were great. And I asked him, I said, "What are you going to do with the rest?" He goes, "We'll put it in the window. Nobody eats it. We'll feed it to the fish." I said, really? He said, yeah. And I said, when are you guys open? He said, we're 24/7. And so, that night, I get up at 2:30 in the morning. I'm putting my sandals on. And my wife says, what are you doing? I said, I'm going down and get a piece of anchovy pizza. She says, it's 3 o'clock in the morning. Why are you doing that? I said, because I can.
Yeah.
So I walked down there at 3 o'clock in the morning. I asked the guy, would you make me an anchovy pizza? And he said, sure. He made it. I had a couple, went to bed, had a few Tums before I went to bed. And I just thought that was the coolest thing in the world.
Yeah.
So anyway, not to talk.
It wouldn't do for them to have a good. I bet they have a good deli or sandwich shop somewhere.
Oh my
too.
gosh, they got every kind of thing you can think of. They got cold cuts like that. They got hot meals. They got a cafeteria that's just got something going all the time.
That's amazing.
It is really.
I've always heard that people who love it, and there's people that don't love it. But anyway,
there's a cruise line that I'm thinking about going because they advertise. They said there's 2 things we don't have that all cruise lines have, and we don't have one: kids or casinos.
Really?
Yeah. So I don't mind the kids, but I mean, if when you go on a cruise, that like one of the ones that was real family oriented, there's lots of them all over the place.
Yeah, I think my kids, my daughter and son-in-law, they've got a Disney cruise planned.
Yeah, I mean, purely kid oriented.
Yeah,
they're very cool.
Yeah, they've got a Disney cruise planned up for toward the end of the year sometime. So,
but maybe in your retirement years, it's just you and the wife. You kind of like to go on one that doesn't have a lot of kids.
Yeah, I'll have to knock her out to get her on the boat.
Well, a little Dramamine will loosen her up. You might have to have some anyway if she gets motion sick, right?
Yeah.
Anyway, hey, yeah, we had a. It's been last week and the last 2 weeks have gone so fast.
They really have.
We stay busy at the office. We do. Been doing a lot. We want to talk a little bit about conservatorships, just briefly. I've talked about them before, and just to remind people, if you haven't heard me talk about it before, a conservatorship, we talk about power of attorney. As a matter of fact, we were talking about one associated with you, with Mike a little bit. And power of attorney is the ability where you sign a document that says, I give my wife or my oldest child the authority to make decisions for me if I can't make them myself.
Right.
Okay, so something happens to me, like I become incapacitated, I may have a stroke or get hit by a bus and go into a coma. I mean, whatever the circumstances are, I become incapacitated. And when I say incapacitated, that means unable to make my own decisions, which means my cognitive ability is impaired.
Right.
So when I say incapacitated, it doesn't mean your hands are broke, your arms are broken, and you can't write, you can't sign. I mean, that's not an incapacity. You can always have somebody sign for you.
Right.
But I mean, your decision making, which is called the cognitive part of your brain, your decision making capacity is impaired.
Sure.
And so you're not really trusted to make your own decisions, is what it boils down to. But if that ever happens to a person, what you really want is a trusted loved one that will make them for you. Okay, so typically most people will name their spouse.
Sure.
And then maybe an adult child after that, stuff like that. So they're good to have because usually when you come incapacitated, it's not something that creeps up on you. Now, if you get Alzheimer's and those progressive diseases, it does.
Yeah.
But for a lot of people, it happens pretty quickly.
Yeah.
Like a stroke. You never see that coming.
Right.
Anyway, so they're good documents to have at any age. But if you don't have one, let's just say you keep putting it off. Some of the folks I deal with, especially some of the elderly folks, they tell me, I'm not doing a power of attorney. When I say, why not? I mean, it's a very good, protective, preemptive measure. And they say, well, if I do that, I want my kids spending all my money. And it's like, it doesn't work that way. It's a fiduciary duty. You know what I mean?
Yeah.
A fiduciary duty means if you literally are to stand in the principal's shoes and do what the principal would do if the principal could do it.
Right. Exactly.
And if you do something that they want to do, that's a breach of their duty, and somebody can, cry foul, and the court would remove a person like that in a heartbeat, just like that, to stop what's going on. And so they get a misunderstanding of it. And most of the times I can kind of talk them into it's a good idea to have one. And so, but some people feel like, anyway, the point I'm getting at is if something happens to you and you do become incapacitated and you have not done a power of attorney, now you've lost, because you're incapacitated, you have the inability to appoint somebody.
Right.
Because you have to sign this document. It's a legal document. To sign any legal document, you must be of sound mind and disposing memory, which means you got to understand what you're doing. And if you're cognitively impaired, you're not able to understand what you're doing. And so now you don't have one. But you got somebody like your wife. We'll pick on you because you were on vacation and you need to be picked on. So you become incapacitated and you don't have a power of attorney. And now Teresa needs to do things for you, right? And I know a lot of things are joint, but to say she needs to do things for you, just because you're married, she does not have the authority to act on your behalf on a lot of things. And that surprises a lot of people, but you don't. And so what she has to do, if there are certain things need to be paid that are not joint, or certain things here at the radio station where you're employed, you have to deal with stuff, she doesn't have the authority to do it. Now, if she doesn't have the authority to do it, she has to go to court and get what's called a conservatorship.
Yeah.
Now, a conservatorship is what we call, I mean, here's a good way to think of it. Everybody's heard the term, but a lot of people maybe not sure what it actually is.
Yeah.
When you hear the term conservatorship, that's what we call it here in Tennessee. Some states call it guardianship.
Yeah.
We call it conservatorship. And the good way to think of a conservatorship is it is a court-ordered power of attorney. Because if you become incapacitated, the only one that can make a decision for you involuntarily is the court.
Right.
And it's a adversarial process, and it's very expensive and kind of drawn out. It costs every bit of anywhere from $7,000 to $10,000, which I think is an expensive procedure.
Right.
And 5 months, 4 months to 6 months it takes before it all goes through until you finally end up with the letters conservator, where the person has the authority to act.
Yes.
Okay. And so, but all that is completely resolved if you sign a simple power of attorney now while you're of sound mind.
Yeah.
If somebody comes in and wants power of attorney, I mean, they're very inexpensive documents. I think we charge something like $250 for power of attorney for healthcare, power of attorney for everything else.
Right.
The HIPAA waiver that goes with that, it's another document or two. Very inexpensive. So there's no real good reason not to have one. But anyway, the point I'm making is we have a couple of those going on right now. And if you don't have much in the way of assets and stuff, it goes a little smooth. But if you're like an average person, have a home and money in the bank and, have some assets, it becomes pretty cumbersome because there's a bond requirement on the conservator statute. And it's based on the amount of personal property you own, which is hard to put a value on, but
Sure.
You have to post a bond that's equal to the value of your personal property, which is a hard thing to put value on. But there's a relief to that bond if your personal property totals in the amount of less than $10,000, which may sound like a lot, but if you got a car or two, you've already exceeded that, right?
Right.
Any vehicle, you're going to be over that. Even a clunker is probably close to worth $10,000
Yeah.
these days. But so you have to post this bond, and the bond usually, if I did one recently where we had to post about a $230,000 bond, and so people don't have the money to put up, which you can do that. But the conservator sure doesn't have that. They're the one acting. They're doing the person a favor, and now we got to hit them with bond because that's what also helps keep them from going rogue, right?
Yeah. Okay.
Because if they cause the damage, then the damage is going to come out of their bond.
All right.
If everything's fine and the person passes away or becomes of sound mind again, you get your bond back.
Yeah.
But you have to get this bond, and you usually have to go to an insurance company and get a surety bond through them, and it costs about, I don't know, I think we did one. It cost $1,000. It cost $1,000 was the cost to the person to get the $230,000 bond.
Wow.
Like the insurance company did, and that's money that won't come back.
Yeah.
And so I'm doing one now that it's the first time I've done it, but I have a husband and wife. The husband's got some issues, and they're pretty severe. And the wife they never had power of attorney. Now he simply cannot sign one, and so she's pursuing the conservatorship. And now, when you start looking at the property that would address the bond statute, everything is joint. So that makes it cloudy as to what we're going to call it. So I was looking at the statute just the other day for this very case, and just kind of going through it word by word.
Yeah.
And I came up with something I think will probably work, but there's a reference in there about the court waiving bond for good reason. They can waive bond for good reason, and I think the good reason would be their husband and wife. So when she manages his money, she's literally managing her money, right? I mean, it's typically one and the same. It's not like if this is your uncle and you're managing him. It's all his money, and you're just doing what his money is supposed to do.
Right.
But if you're husband and wife and everything's joint, you're managing joint money. What you don't want is having somebody who just isn't thinking right, doing like, I have a mother-in-law that gets sucked into this stuff all the time, all these scams and stuff. Or,
Sure.
You don't want, just because it's a joint account, you don't want their name on it, because they can turn around and say, hey, I just sent $50,000 to some guy in Zimbabwe that sent me an email and said he was in dire straits, and that's something like that. They can do that because they have authority over the account. So when you take them off the account, so that things like that won't happen, you're actually doing them and yourself a big favor as a couple. So I think that's good reason. Then something else has to be satisfied under the statute, and nothing applies except for one that says if a written report to the court, if a document recommends waiver of the bond.
Yeah.
And I did some research because when they say a document, I'm thinking, okay, we talked about the petition that we write or something else. And the research I've done tells me that the guardian ad litem's report, which is a independent person, was one of the things that makes conservatorship expensive, is if I do the conservatorship, I file a petition. But then the court's going to appoint another attorney called the guardian ad litem to go talk to the proposed conservator, talk to the ward and see, and make an independent report to the court. Basically, does the person need a conservator?
Right.
And is the person that who's petitioning for it the best person for it? And
Right.
and they make a report. But if they say in there the bond should be waived, then I think the statute will waive it. So we'll see how that works. It's the first time I've tried it. There's always been a situation where the bond was either appropriate or we didn't have to make it.
Right.
But this one, it doesn't seem appropriate to me. But I mean, I'll do what the court says because that court has to finally do it. They have to put that in the order. But I'll pitch it, to see what we can do.
Wow. Okay.
So, anyway, but the conservatorship now, the other thing you have to do when you do a conservatorship, two things. One, there's an annual accounting. Now that's usually not too bad. If the assets are numerous, it can be a little more cumbersome.
Yeah.
We help folks. We kind of have form documents to fill out for that. It's just a kind of a court basically wants to see every year what the status is, make sure it's not being pilfered, stuff like that.
No.
So it's a check and balance thing. I get why we do it. But they also, shortly after you file the conservatorship, you have to file a property management plan. And that's about an 8 or 9 page document. We got to fill out what all the assets are and kind of what we're going to be doing with them. And that's not too cumbersome for the average person, but whenever we do conservatorships, we're usually always doing it for some 10 care reason to get somebody eligible for 10 care
Right.
that didn't have the power, right? And we want the power of attorney to be doing all the 10 care stuff. And so now we have to put in this property plan and something like, hey, they have all these assets. And what we want to do is divest them of them to get them eligible.
Sure.
So, and not only that, if the power of attorney is a adult child, we're saying we're going to take all these assets, put them in the agent's name.
Yeah.
And it may look like self-dealing or self-serving, but it's not, because we're doing that all for the reason of
Right.
eligibility.
Right.
It's going to end up with that person anyway. We're just doing it now so we can become eligible during life and stuff. So there's a lot to it. And again, I mean, you probably heard me talk about power of attorney many times, but it's worth saying again that when I say everybody needs a power of attorney at any age, please don't just blow that suggestion off, because it is very cumbersome for your loved ones if you do blow it off and don't have it and become incapacitated.
Yeah.
It is a lot for them to deal with. It can get costly to your state. Cost you a whole lot more than what it would do just to do it during life. I mean,
Sure.
the cost during life is de minimis, just de minimis.
Yeah.
The cost of a conservatorship can get pretty healthy.
Yeah.
Can get pretty healthy, and it's not necessary. None of it's necessary.
Yeah.
But I probably hear it. I hear it often. It's like, no, people call and say, "Mom's in a nursing home. What can we do?" And I always say, does she have a power of attorney? No, she never got around to doing that. We told her, asked, and they always say, we told her, Mom, you need one. Mom, you need one. She just never did. Well, that puts us in that arena. It's the only remedy at law that's available once you become incapacitated and can't do it yourself.
Wow.
So they're easy to do. And then a good thing to do in a power of attorney is name several people.
Yeah.
I mean, I got 3 children, but I wouldn't. Typically, people name their spouse first. Now, you don't have to. I mean, you can name the mailman to be your
Right.
agent if you wanted to. It's up to you. But you name the people you want doing it. Typically, it's the spouse first. And I got 3 children. I would name my 3 children one after the other. Okay. And now I have a consecutive order. So if my wife can't do it, which means, and the language we use is if she is unable or unwilling to perform. Now
Sure.
that encompasses her being predeceased.
Right.
Or it encompasses her being incapacitated herself, or it encompasses maybe she moved off to Sweden or something, just physically can't do it, or somebody that just says, I don't want the job. Because you
Right.
can't force somebody, you can't make somebody be a fiduciary.
Okay.
Just because you name them doesn't mean they have to do it.
Yeah.
And if they do it, there's always language, they certainly can resign.
Yeah.
Because people's circumstances change.
Sure.
Somebody says, sure, I'll do it, and they're doing it for a year or two, and everything's going great, but their circumstances change. They say, you know what, I just can't do it anymore.
Yeah.
I'm moving to Canada. It'd be too hard to do it long distance or something.
Yeah.
So, you can resign. So, but you got to name several people, because if you run out, now you've lost the ability to add people to it if you're incapacitated.
Right.
So, but for myself, I have 4 people in a consecutive order. it's very remote that I'm ever going to get to that fourth person.
Yeah.
For a couple of reasons. One, first of all, the first one has to fail. So if my wife is unable and willing to perform, that fails and goes to the next one, which would be my oldest daughter.
Yeah.
Then if she's unable or unwilling to perform, it goes to the next one. Okay, I mean, it's very remote that would happen.
Sure.
But another built-in thing is if people predecease you or become incapacitated and cannot be your power of attorney, you're going to know about it, right?
Yeah.
Because you're still alive. Hopefully, you're not incapacitated yet. So if something like that happened, you can say, you know what, my first two picks are gone, and I'm down to my third pick, so I might want to revisit this power of attorney, put some other people there.
Right.
So it's very remote. But even what I've been doing lately in the last couple of years is under our General Durable Power of Attorney Act, I've been putting into my power of attorneys for people, naming myself as an agent appointer. Now, what that means is if I prefer you make the picks.
Sure.
Because those are the people you want. But if for some reason we end up with a vacancy and we can't fill it because you've reached your incapacity, right? And you're not able to fill it. As agent appointer, I can fill the vacancy for you without going to court. And what I'll do is, it doesn't need to be me, but it does need to be somebody like me that one, knows and understands the law, and two, understands what your family is and what they're like. So I would vet other people in your family or friends or something, and then I would have the authority to put that person in place. So I'd get somebody that's going to do it and going to not be rogue about it.
Yeah.
And put them in. And that's just another building thing. I've never had to use it yet because most people name 2 or 3 people, and it's pretty hard to run out. But it's available to not have to go to court and deal with the conservatorship, because the conservatorship, I mean, we do them all the time because people just don't get around to doing it. But when people get involved with it, they say this is really cumbersome, and I wish I could make it smoother for you, but I can't. It is a procedure.
That's the way it is.
Well, and you can avoid it by doing a power of attorney sometime before you become incapacitated. Don't wait. They're simple. They're easy. I just don't know why people don't have it.
Yeah.
It's the same old procrastination thing. And
it is.
And I procrastinate too.
Yeah, it is. We simply do it. We assume that we got all the time in the world sometimes.
That's true.
Well, I'll do that later.
Yep.
I'm a professional procrastinator, by the way.
Like people's in their 20s and 30s.
Yeah.
I'll worry about that later. Like I said when I was in my 20s or 30s. I said, I'm indestructible. Nothing's gonna happen to me. I'll be all right. I'm careful. When I jump off a roof that's too high, I'm careful.
I'm learning better. I'm learning better.
When I balance myself on a ladder, I'm careful about making sure I'm
Well, do you want to take a phone call this morning?
Sure.
All right.
I didn't hear a ring.
Oh, well, I had the ringer turned down there for a little while. And you're on with us.
Can you hear me okay?
We can.
I know the situation where this has happened. What was put in the will, now I didn't see the will, but I was told this was put in the will or whatever they had, that one person was the person that was their power of attorney or whatever you call it, took care of everything. But then they had succession. They had the second, third, or however many. Well, that person developed an illness and couldn't do it. So everything just about that was set up toward the end of life was the second one. Well, then the first one wanted to come back and get involved, and the places would not deal with this person because all the paperwork was with the second, and it caused some real ill feelings about not only for the. I just wondered if something should be put in something about that where that could have been prevented. Second thing, you mentioned something last week about there was a certain kind of trust that people in real estate needed. It sounded to me like it would be more real estate investors. And I asked you a question, if a trust could be the beneficiary. And I read somewhere about Dolly Parton, it mentioned she had wills and trusts, plural. In other words, if you've got some kind of trust, and can you make another trust the beneficiary rather than a person? I found that confusing. I just wanted to throw that out. You may not understand.
All right, she's gone.
I'm good.
We're digesting.
No, I'm saying there's always a lot in Miss Peggy's questions, and so I was just jotting some notes down along the way so I could.
All right.
It's like I'm pretty sure I have the answer to everything, but sometimes if I give the answer and I start to forget what the question was or other parts of the question, I don't get to it. But I jot some stuff down. So let me talk about it. Let me talk about the first one. First one, really, it's not overly appropriate to put power of attorney in a will. Power of attorney is a standalone document. Now, I've seen it done, and I think you could argue that it's okay, but here's why I strongly advise against it and don't like it one bit. Power of attorney is a document that's during life. It's part of incapacity planning. Okay,
Right.
your power of attorney for somebody expires at their death. I have people come in and say, "Daddy died last month, but I'm his power of attorney, so I've been paying his bills." I say, "Well, technically, the bank shouldn't accept that because your power of attorney it doesn't exist after death."
Right.
And so power of attorney is a lifetime document. A will is not. A will is called a last will and testament.
Right.
The word testament means at death. It is a testamentary instrument. It has no effect, no legal effect whatsoever until the moment of death.
Mhm.
So I have a pretty strong legal argument. Putting power of attorney into a will is hard to enforce because you physically cannot execute a will until you're deceased.
Yeah.
By definition of law. So I don't know how you can exercise the portion of the will that says you're naming somebody as agent as power of attorney. So if it's allowed, it's going to be very cumbersome.
Yeah.
So what we do exclusively is, if somebody wants a will, we do a will on it. It has to do with distributing property after death. If you want power of attorney, we do a separate power of attorney that is a document that goes into effect right now.
Mhm.
If you want it to go right now, or you can say, I don't want this is a document, but it doesn't go into effect until my incapacity. But still, even if you become incapacitated, we're not talking about death. You're still talking about life. So, but anyway, to get to the other question she said, let's just say you have a power of attorney. For the purposes of the answer, who cares where it came from or where it was? It exists. Okay.
Yeah.
And you name choices one and two. Okay. My oldest daughter is first. My son is second.
Yeah.
Okay. Now, for some reason, the oldest daughter, the first one, like she said, couldn't do it, or resigned,
Yeah.
or said, "I can't do it. My circumstances are I can't do it." And so you can do that, and you can resign, and then because it's consecutive order, it will go to the second one, right? The language is if the first one's unable or unwilling to perform. In this case, it's unwilling, not because they're being dirtbag, because they can't. There's something
Sure.
going on in their
Something
lives
going on
that
they
keeps
can't.
it from doing it.
Sure.
And of course, you want them to do a good job. So if you're a fiduciary, you're required to do a good job. And if your circumstances keep you from doing that, then you should resign. And so they resign. Now, here's the thing. Once they resign, that's permanent. I mean, I don't think you could put in, and I would certainly not want to put in, that if somebody resigns and then later on they can, that they can do it. Okay. But now, so when one fails, now the second one is the first. They're the one up.
Sure.
And so now they have that authority.
Okay.
So if now she said something about now after that one's been acting for a while
Mhm.
and doing things, the first one said, "You know what, I'm ready to do it now." Now I could see that with an adult child. For
Sure.
some reason it couldn't do it, but now they come back and say, "I want to be dad's because I was his first choice and now I can do it."
Yeah.
And the question is kind of theoretically, when the first one comes back, something's got to be changed to put them back in power. Nothing's going to happen automatically because the second
Okay.
one is now there. I've never had this happen. I've never had the request. This is the first I heard it. So I'm nuking this out under general principles, fundamentals, and I think I'm right. But I would look into it if this came up to see if we could do this. But once the one is empowered, then they're the one up. The first one could be, even if the second resigned, the next one in line is if there's a third is going to be there. Now, it's possible it could be changed by court action, which we'd never want to do that.
Mhm.
Or if the principal can do it. But if the people are acting, that tells me the principal's already incapacitated.
Yeah.
So, and now the question, I guess, is could you have language in there that if I pick my daughter to be first, and for some reason she can't do it, then I want my son to be second. But if for some reason my daughter now can do it, I want her to come back in and take over for number two. Technically, a legal document like this, there's a lot of weight put on what it actually says,
Yeah.
because you are giving this authority. So I'm saying I wouldn't recommend it because it seems cumbersome to me. And she said it caused hard feelings. Well, I mean, we have to say, here's what I say about the hard feelings. We got to put those aside because what was important was somebody representing this person.
Right.
And the first one couldn't do it. And the second one stepped up and did it. Now,
Right.
it's hard feelings, too bad. The person, the principal was taken care of.
Right.
The hard feelings maybe should have come up when the first one couldn't do it.
Yeah.
But anyway, I put no weight on the hard feelings when we put this together because the whole thing is to serve a purpose, and that did.
Sure.
So my answer is you probably could put in language in there,
Mm-hmm.
and I think the argument would be the document itself dictates who your agent is and under what circumstances. Because if you name somebody, let's say you name your wife first, I'm using you because I don't have any minor children.
Yes.
You name Teresa first, right? And you name Daniel second.
Yes.
Daniel's a minor, right?
He is at this point. Yes.
So, but we could put language in there that says Teresa's my first choice, Daniel's my second if he has attained the age of 18 years. So it's conditional for Daniel, right?
Right.
Hopefully you don't lose your muscles or marbles until he becomes adult.
Yeah.
And then if it comes to him, he could do it if that condition is satisfied. And we just leave that in there. So once he turns 18, then it's no longer a condition because he's now the second choice.
Yeah.
So I think you could put that in. I would really want to walk through it with you and maybe advise you not to. Unless, if there was a really, really good reason to do that, I think we could put in, I think technically it would be enforceable. I think it would confuse a lot of people. And here's why. When you go to the bank, and this is the same thing that she said this person was running into. You go to the bank, they understand power of attorney, and they'll do what it says. And I have a person that's taking care of the parents in 10 care, and the father, or the husband, resigned because he was getting old and decided he wasn't the best to do it. So he did an affidavit and resigned, and we showed that to the bank. And the bank looked at that and they said, okay, I guess I see what's going on here. The first one resigned, so now the daughter's up. And they've been honoring that, okay?
Yeah.
And they were a little bit touch and go with that, but after I explained it to them and I showed them exactly in there that the person can resign. If they resign, they just have to give a written notice, and that's what we're doing.
Sure.
Now you know that any action that comes through from the husband is not acting on behalf of the wife. And that's kind of what it said in there to do. So I think coming back with the husband coming back now and saying, okay, I feel like I can do it now. Maybe you can write that in there and maybe be enforceable, but as a matter of practical fact, I think it would be a nightmare. I think because because whole idea with power of attorneys is you're dealing with other people, honoring it.
Yeah.
I mean, you're doing stuff, but you're doing the bills you're paying, the money you're dealing with. You're dealing with those financial institutions. And if they don't understand it, they're going to fail. It's closed.
Right.
You know what I mean? So I think technically you could do it. It doesn't sound like a good idea unless there was a compelling reason that made it a reason to do it. So switching from that, can you have a trust that's a beneficiary? Or can you have a trust that makes the trust a beneficiary? The answer is yes. Some people, if you have real estate, like this is down your alley, let's say somebody has several pieces of real estate.
Yeah.
And they're income producing, okay?
Sure.
I have known people that would elect to put each piece of real estate into its own trust. Now, there's advantages to that, depending on what you're using real estate for.
Sure.
If it's income producing in the farm, like if somebody wants to do like one of our asset protection trusts, and they have an income producing farm, and them and maybe a family or two are working it and relying on it,
Mm-hmm.
I would say let's do an asset protection trust for you, the individual, so you and your wife, and do one where you just put the property in. Essentially, what we're going to do is have the property in trust, and you lease the property for the business. Okay?
Yeah.
So there's several things you can do, but essentially you can have multiple trusts. Now you can have a trust for a beneficiary. Here's a good example.
Okay.
Often, some people come to my office to be mom and dad, and they do a trust, and the next thing you know, I'm talking to son or daughter,
Right.
an in-law, right? They want to do a trust too, or vice versa. I'm talking to an adult child and they do a trust, and then mom and dad want to do it. Well, let's say mom and dad do a trust, and son and daughter do a trust. Now, if it's, let's just say a revocable living trust where you really want to put all your property into, and they say, hey, I'm going to inherit something from mom and dad someday. So what we do is go to mom and dad and say, hey, you got 2 kids, you want to leave 50% to your son here. So, but all his property is in a trust, and if you leave it to him, he's just going to turn around and put it in the trust, because in a revocable living trust, you want everything in there sort of waits probate, right?
Sure.
So why don't we change your trust? Simple modification. Instead of leaving it to Tom, my son, the individual, let's leave it to Tom, trustee of his trust. And now his inheritance goes to his trust immediately. That's the beneficiary. So the trust has another trust as a beneficiary. This is traditionally done often when somebody's special needs. If somebody has special needs, they can't own a lot of property, right? They're bound by the same rules as 10 care. You can't own more than $2,000 worth of property, or you'll lose your benefits.
Okay.
I'm specifically referring to SSI. SSDI is not limited, but SSI, if you own more than $2,000 of assets, you're disqualified for SSI benefits. Now,
Okay.
the way we prevent things from that can happen, let's say you write in your will and you say, you know what, I got a child that's SSI, so I'm going to leave him a bunch of money in my will at death or my trust. So I leave it to this child. Problem is, the minute that child inherits that, we've destroyed his eligibility.
Yeah.
Or let me put it this way, if he still has that money, by the first day of the next calendar month, it's considered a resource. And now he's over-resourced, and now we will have lost those SSI benefits, which were very difficult to get. We don't want to be in that boat again.
Right.
So what we do is say, okay, we got special needs person, let's make them a special needs trust. Now, let's leave your inheritance to that trust, because that trust could have $1 million and not disqualify him. Because
Okay.
what's in the special needs trust, of course, is for the benefit of the special needs person. And so there's another example that we very, very routinely do where a parent's trust will leave property to the child's special needs trust. So going from trust to trust, very common, can do it. So the
Okay.
trust can be a beneficiary and it can be the beneficiary of another trust.
That's interesting.
Because a trust under both state and federal law is interpreted as an individual. It is not a business entity. A lot of people think that, and I run it, banks think that. They say, well, if you put money into it, if you put your money into your trust, that's a business account and it has a higher minimum deposit and the service fees are more. Well, we got to go talk to the bank and say, no, it's not. It is not a business entity. It's not an LLC. It's not a corporation. It's not a partnership. Okay. It's to be viewed under state law as an individual, a
Really?
person. It is a person by law. And so you treat it as a person, you just give it a regular individual account. So when you have a beneficiary, you certainly can name a person the beneficiary. So when you name a trust, you're naming a person.
Oh,
So
okay.
it is definitely allowed. It does all the time.
Okay.
There's sometimes when it works very, very advantageously. The special needs trusting is a perfect thing of what you do because the last thing you want to do is destroy those benefits
Yeah.
to make somebody ineligible because they're a nightmare to get. You know, this kind of thing where they turn you down 3 times before they ever say yes. It's just routine. You apply, they say no. You apply again, they say no. You apply again, they say no. You apply again, they say okay. Somebody once said it's kind of like trying to become Jewish. They want to make sure you want to do it before they let you do it. But
You have any insight on why that is?
no, I don't. I don't do it. I refer it because I know people that do.
Yeah.
Social Security or SSI or SSDI, and they get you eligible. But it's a long, drawn-out process. I think maybe there's some tenacity issues. Like they want to make sure. I mean, I'm sure there's a percentage of people that get turned down the first time and then just don't do it. Don't reapply.
Yeah.
And probably don't reapply after the second time or the third. But if they hire somebody to do it, that person's going to say, hey, they're going to turn us down a couple of times, and then we'll probably get there. I don't. It's too chaotic. It's just it doesn't do anything for me. The
Yeah.
subject matter. If I get somebody that needs to make an application for that stuff, I refer them. But you know, one good thing about that is when you go for SSI or SSDI, you don't have to pay the attorney. They get paid by the process.
Oh, really?
Yes, you do not have to fund. You don't have to pay them to do it. They get paid once you're eligible. And so
Okay.
that's an advantage. Because usually, and the reason is because if you're applying for that, you haven't got a lot of money to pay an attorney anyway. So if you need the help, that's
You think there's maybe a strategy within SSI to do that on purpose and in hopes that they don't reapply again?
Maybe it helps. Maybe it helps to understand that SSI used to be what we call welfare.
Yeah.
They don't call it welfare anymore. Now we call it SSI. But it is welfare. In other words, it's welfare meaning you have to qualify for these benefits, and if you qualify under the criteria, then you get it. And it's a set amount. It's the same amount every month. Certain deductions can be made, but it's something like $972 a month if there's nothing modified to it. It changes from year to year.
Okay.
But then you have SSDI that's not what we call means tested. It doesn't matter how much money you have. And usually when you have SSDI, how much you get paid is based on your disability. So some people get $1,000 a month, some people get $2,500 a month, some people get $1,800. That's based on the percentage of impairment, stuff like that. But you can get as much of that, and you can still have a special needs trust and put it in to use it for that reason. But you don't have to worry about losing those benefits because those benefits are based on your disability, not the amount of resources that you own.
And you may not know this, but you might.
Excuse me?
When they turn you down, like you apply first, do you have to wait a certain period to apply again?
I believe there is a waiting period. Yeah.
Okay.
It's not very long, but
Okay.
I believe so.
Okay.
You
I
can't
just wondered.
you can't just pepper them with
Yeah, that would be
one after the other.
yeah, interesting.
I don't think it's very long though.
Okay.
Well, another thing that's like that is, I don't know the number, but what sticks in my mind is 60 days. But I think the 60 days sticks in my mind because of another thing that we do. You hear of people going into, okay, you're just thinking a senior citizen of age
Yeah.
falls, breaks their hip.
Yeah.
They go to the hospital, right? They
Right.
give you a new hip or they fix it, your hip or whatever they do.
Right.
And you're there for what they call 2 midnights, okay, 3 days. And then they say, okay, we fixed your hip, but now you got to rehabilitate, learn how to walk on it. Because, you know, it takes a certain amount of physical therapy.
Sure.
So they send you to a long-term care facility, a nursing home.
Right.
And that's where you rehabilitate. That's that thing where we talk about, where we say, that's not long-term care. It looks like it, but your Medicare is paying for all that.
Yeah.
You know, we talk about it, and it can be up to 100 days and stuff like that. And
Right.
we've talked about that before, and maybe
Right.
we'll talk about that again on some day. But when that happens, you have this thing where, like I said, you may be there for 100 days.
Yeah.
And during that 100 days, Medicare will pay 100% of it for the first 20 days, right?
Right.
After that, it's an 80-20 split, where you pay 80%. But for most people, 99% of the people, their supplement to their Medicare pays that. So the person is very rarely out of pocket.
Right.
And that can go for 100 days. Well, however long that goes, let's just say it goes the whole 100 days. And that comes to an end. Because at the end, they say, whether you're rehabilitated or not, we're not paying. This is all we do.
Yeah.
And so they stop paying. Or if they stop paying after 60 days because you managed to learn how to walk good, and they say, okay, you're rehabilitated, we're going to stop paying.
Yeah.
When that comes to an end, if you fall again and go in, that whole process will start all over again, but only if there's 60 days between end of the first one and beginning of the next one.
Oh, really?
Yes. It's called a spell of illness. So if you have a spell, here, let's say, okay, let's use some time frame. January 1st, New Year's Day. You had way too much to drink. 5 minutes after midnight, you know, you fell and you broke your hip. You go to the hospital, you're there for 2 or 3 days. They send you to a nursing home to rehabilitate. You're there for 60 days, 90 days. And so now we're at April 1st. We've been there January, February, and March. Okay?
Yeah.
I'm just using numbers so we can talk about it with
Yeah.
So you've been there for, because the 100 days includes the hospital stay.
Sure.
So 90 days, they send you home, they stop paying, okay? Now it's April 1st. So if something happens to you May 1st, you got to go to the hospital, this is not going to start all over again. Now it's a whole different ballgame. They're not going to pay you. They're not going to do the paying for the rehab now. If it becomes, let's see, April 1st, August 1st, you fall again.
Yeah.
No, I'm sorry, the one before, it'd be July 1st, I think.
Yeah.
I'm trying to make it a simple example, and I can't hardly do it in my head with the calendar. But I think July 1st, which is 60 days or more that you fall again,
Mm-hmm.
it will repeat itself all over again. You'll go there, they'll send you, Medicare will pay 20% they'll pay all of it for 20 days, and they'll
Okay.
split it after that. But there has to be 60 days between spell of illness, and they're defined as the end of one, which is when they terminate,
Yeah.
and the beginning of the other, which is when you go to the hospital. So when you talk about doing the SSI or SSD, I'm pretty sure there's a period like that. I don't do it myself. Like I said, I usually refer that out to people, so I don't know the number of days that is, but I'm willing to bet there's such a philosophy. And it exists. That's a non-abuse kind of thing. You know what I mean? Now, I mean, people can genuinely get hurt a second time within that 60 days, but the law presumes that if you do it sooner than that, it's too much on the system, or it's not genuine. You know, I don't know. I don't write the law. I have to deal with it, and I don't like it half the time, but I have to deal with the way it is, and that's the way it is. And I think that the bottom line is the question was: is there such a time frame between the two on SSI and SSD? I'm pretty sure there is. I'm not sure the number of days.
Oh.
But the methodology is the same. These government benefits, and you're getting, and they're helping you, but when they help you, it's not just carte blanche. So.
Yeah. Okay. Wow.
But that gets a little out of my lane because I always ask. I know two people that do that, and I tell them, hey, if you need to get this disability, go after it.
Yeah.
Because you don't have to understand the rules. You can hire an attorney that does that, and the ones that do that usually do only that.
Yeah.
And you don't have to pay them. I mean, they get paid, but it's not you paying.
Yeah, I've run across a person or two, over the years who said they were trying to get disability and couldn't. I hear that all the time.
And that means denied. Huh?
Yeah, denied.
So stay with it.
Yeah,
Because
so-
I think I don't know if I know a case that after 3 denials, they never got it. Because I don't get, you get out of my lane.
Is it better to go ahead and find an attorney who does that for you to start with?
I think so.
I would say
If it's
so.
no out of pocket to you.
Yeah.
And usually you probably couldn't do it anyway. If you're in that position, especially SSI, if you're in
Yeah.
that position, I mean, the SSI means you're disabled to the point where you can't take care of yourself. So you
Yeah.
can't get a job, or at least enough of a job to financially take care of yourself.
Right.
So if you need to hire an attorney to do that, you're going to be come right out of the gate. You're going to say, I can't even do that.
Right.
And that's why the structure is that they get paid out of the system. It's less than they normally get paid. You know, a lot of people, when they in personal injury, they can recover a third. I think in these things, I think they can recover 20% of the first year or something like that.
Right. Okay.
But it's not like every time you get a payment, some of it goes to your lawyer. The administration pays that.
Yes.
But so I would say if you're going to try and get it, you know, there folks, their job is to get you eligible, so they know and understand the rules. I'd go meet with one and
That's interesting.
tell them what they need to know about your disability. They'll ask for the medical reports and all these things that define the disability,
Sure.
right? Let them do all the work, because for 2 reasons. One, you probably couldn't do it. It's too much to understand. Second of all, you probably couldn't afford it, and you don't have to.
Yeah.
And if you don't understand, it's a procedure. So when you do something wrong, they are perfectly in their rights to deny you because you didn't do it right.
Yeah.
And you may not even know you didn't do it right. That's usually the case. You say, okay, here, I'm just going to fill this in and send it in. Well, what if it says it has to be done within a certain time frame of something? And
Yeah.
if you didn't know it, you can't just say, oh, I didn't know that. I'm not a lawyer. I didn't know that. They're going to say, well, wait a minute. You could have hired it. You could have gotten a lawyer to do it. We're not going to. You can't be treated special. Reminds me of My Cousin Vinny. Remember the movie?
I do.
And he's talking to Fred Gwynn. You know,
Yeah.
rest his
Oh,
soul.
yeah.
And Fred Gwynn says, "I expect you to know this procedure." He says, "Now," he says, "I react harshly if you don't."
Yeah.
He said, "You'll be given no leeway whatsoever." That's exactly what he's talking about. You can't come in and say, "Oh, sorry, my bad. I'm not familiar with your rules." So you can't, even
Yeah.
though I made a mistake, just forgive it and let me move on. If you do that, you're working an unfair tort to your opponent, because he has to be bound by the law, right?
Yeah.
Or the rules. So when you go in there as a pro se, when you represent yourself or something, and something goes south, and then when you find out what you did wrong, and you can't just say, "Hey, I didn't know, so let's just forgive that and let me go on." They don't have to do that. They're well within their rights to deny because of that. You had an opportunity, and now it's going to be even harder to argue
Sure.
why you didn't do it yourself when you can hire an attorney that you don't have to pay.
Yeah.
That's a hard argument to say, well, I wanted to do it myself. And then the answer is, well, if you want to do it yourself,
Right.
it's great. You can do it yourself, but you get everything that goes with that.
Okay.
So, get these people to do it for you. That's the whole system is designed so that you don't have to pay them.
I like it.
So if you know anybody, like I said, if people call me and we need to, even if we need to do that for
Yeah.
one of our crisis clients, I get other people. I get the people that do it to do it. It's out of my lane. My wife likes to say, "Stay in your lane."
Yeah.
And I know how it works. Basically, I get the concept. I understand it to a certain extent. I know what to do with it when we have it.
Yeah.
But getting it is out of my lane, and I don't really want to go in that lane. So
Okay.
it's just not something I want to do. But I know people that do it, and they do it very well.
Well, interesting stuff this morning.
It is.
A little bit different. Finding out some stuff there about some issues that, especially the power of attorney thing
And the conservatorship.
and
That's
the
right.
conservatorship. People need to know the difference in that and what it takes place. We're down to about the last 4 or 5 minutes.
I see that.
And
How did we get there?
and it goes quick. It goes quick. But I want people to know how to get in touch with you,
Sure.
know where your office is, and all that kind of stuff.
Oh, I will. And I do have a seminar coming up. So
That's right.
Certainly, of course, if you want to talk to me, you can call or email me. My office is Pierchoski Estate Law, and my telephone number is 931-363-7222. 931-363-7222. You can go to my website, estateplanstand.com. It's technically PierchoskiEstatelaw.com, but if you want to get there easier, estateplanstand.com. You can get the phone number there if you want, or if you want to ask me a question by email, which is pretty popular, you can do that.
Yep.
If you want to see what's going on, there's a lot of cool stuff to read on my website, but I have a calendar there too that you can see where I'm going to be.
Yeah.
And the next public seminar that I'm doing is 2 weeks from tomorrow, I think. So that's September the 12th. Okay, that'd be right.
September the 12th.
So,
Okay.
2 weeks from tomorrow. And that's going to be It's a Saturday seminar, so it's at 10 o'clock in the morning.
Yep.
That's the one called Will's Trust in the Nursing Home. It's our most popular seminar. And we're going to be doing it right down on downtown on the square in Pulaski at the Star Theater.
Right.
You can't, if you find the square in Pulaski, you'll find the theater. But if you need the address, it's 105 North First Street in Pulaski, Tennessee. Put in your GPS, take you right there. You know, it's a Saturday, so the whole square, inside the square and around the square is free parking.
Yeah.
You know, I mean, it's available parking. It's all free.
Right.
It's all free, but it's available.
Right.
Plenty of parking. And it's a big venue. So if you want to, we like if you're going to come, call and tell us you're coming and how many you're coming. We keep a list at the door. But if you can't commit until the last minute, you know, Friday night, you say, you know what, let's go to that seminar. The reason I couldn't go has changed, and now we can go. Just come on and walk in. It happens every time. Usually we have more walk-ins than well, let me put it this way. Every seminar, some people just can't make it. You know what I mean? They sign up, they RSVP, something comes up and they just can't show up. We have more people walking in every time than we have people that don't come. So it's okay. Just come on. We set everything up with what we know is coming, and we know there's going to be walk-ins, so we add some more tables and chairs.
I can highly recommend it.
And the girls make plenty of muffins. So.
Yeah.
That's right. You were just at one.
Yeah, we just came to our first one.
The last one.
So glad we did.
And so did your partner.
Had a good crowd. My partner was there as well, my business partner.
I already talked to Mr. Hester.
And they've, there's a lot to consider. And it's just so good. The information you would receive there is so worth it. You're worth your time. And it's absolutely free. There's no charge.
I like to call them free educational seminars, and I focus on the word educational. If you want to focus on the word free, that's great. But I think that education is why we do it.
Yeah, absolutely.
Because it gives you options. And I'm going to tell you right now, if you come to that, you're going to hear about options you didn't know you had. Yeah. And some of them, you're going to like those options you didn't know you had. Right. And you say, wow, that's great. Is that really true? Do I really have those? The answer is yes. It is. Just because you haven't heard it, it doesn't mean it's not there. That's right. And, the biggest problem with that is surfing the internet about this stuff. A lot of it's not there. And if it is there, it's not complete. And if it is there, it's at worst completely wrong. Yeah. So. Got a minute. At least one. It's a few minutes early for the announcement. So. Yeah, okay. Anyway, seminar September 12th, 2 weeks from tomorrow, 10 o'clock in the morning at the Star Theater in Pulaski, right on the square, 105 North First Street in Pulaski. My office is 2 blocks away on 304 West Judge.
Yeah, beautiful new office.
You can pretty much see it from the old office. Yeah. If the courthouse wasn't in the way, you could see it from the old office. So we moved away, but the good news is we're only 2 blocks away. That's right. And it's nice. It's a house, and we've got a lot more room than we had before. So. That's right. Stan Pierchoski, everybody. Pierchoski, Bulletproof Estate Planning. Of course, we do this every Friday. We do. But I was going to ask you, are you still on the Nashville station too? I am. Every Sunday night from 8 to 9. Sunday nights from 8 to 9. Same show. Different topic every time, but Bulletproof Estate Planning. Yeah. Very good. I knew you were doing that's WTN out of Nashville. 99.7. 99.7. Super Talk. Yeah, I listen to them quite often on different things, and of course, I knew you were there on Sunday nights at when? From 8 o'clock to 9 o'clock. 8 o'clock to 9 o'clock. Now, do you do that from your place? I do. I can do it from there. Yeah. I go there every now and again. Okay. But I can do it. I can do it remotely. It's live, but I do it from my office. All right. Stan Pierchoski, everybody. Until next Friday. Always a pleasure. We'll see you next time.
This is WDXE 1370, W287.
Yeah, sometimes if I'm going to be gone, I can pre-record it.